Welcome in today's talk on jurisprudence. I am Dr. Simranjeet Kaur Gill, Professor in Laws, City University, Ludhiana. Today we shall talk about H.L.A.Hart, the concept of law, commands and orders, the variety of laws, sovereign and subject. So, in introductory remarks, we will discuss about Hart explored the notion of law in a simple command and habitual habits, attempting to explain whether all laws may be correctly understood as coercive mandates. According to Hart, there is no logically required link between law and compulsion. He further emphasizes that seeing all laws as coercive commands imposes a false impression of uniformity on various types of law and many social purposes that laws may serve. He contended that referring to all laws as a coercive commands mischaracterize their purpose and function as well as their substance, manner of genesis and area of application. Hart attacks John Austin's notion of law, which maintains that all laws are commands of a legally limitless sovereign in the province of jurisprudence determined. According to Hart, laws vary from sovereign mandates in that they may apply to those who enact them rather than only to others. Law may also differ from coercive commands in that they may bestow power or privilege rather than imposing responsibilities or obligations. The existence of a legal system. Professor Hart elaborates two minimum conditions that are individually necessary and jointly sufficient for the existence of a legal system. On the one hand, those rules of behavior which are valid according to the system's ultimate criteria of validity must be generally obeyed, and on the other hand, its rule of recognition specifying the criteria of the legal validity and its rules of change and adjudication must be effectively accepted as common public standards of official behavior by its officials. So, it is very important to underscore that the first condition requires only journal obedience. So, when we talk about the journal obedience rather than acceptance by the ordinary citizens, the second condition specifies that officials must do more than merely obey the rule of recognition, change and the adjudication. They must regard these, basically the secondary rules they are talking about here, as common standards of the official behavior and apprise critically their own and each other's deviation as lapses. According to the two conditions, it is possible for a legal system to exist in which only officials accept and use the system's criteria of legal validity, such as society. Hart comments might be deplorably sheep-like. The sheep might end in the slaughterhouse, but there is a little reason for thinking that it could not exist or for denying it the title of the legal system. To explicate the two conditions, it is necessary to elucidate three distinctions basic to an understanding of Hart's concept of law. The distinction between primary and secondary rules. it is very important to discuss how a habit of obedience differs from the acceptance of a social rule, and the difference between rules that imposes obligations or duties and rules that do not impose obligations or duties. Primary and secondary rules according to Hart, a legal system may be best considered a union of primary rules of obligation or duty and secondary rules of recognition, change and adjudication. Hart characterizes the distinction between primary and secondary rules in the following way. Rule of the first type imposes duties. Rule of the second type confers powers, public or private. Rules of the first type concerns action involving physical movement or changes. Rules of the second type provides for operation which led not merely to the physical movement or change, but to the creation or variation of duties or the obligation. In Hart's view, a society might live only by the primary rules of obligation, but will suffer from three defects. There will be uncertainty as to what the rules and their scope. The rules will be static insofar as there is no means of deliberately eliminating or introducing rules, and the social pressure by which rules are maintained will be inefficient because there is no agency for finally settling disputes over violation of the primary rules. These defects may be remedied by the secondary rules that specifies the ways in which the primary rules may be conclusively ascertained, introduced, eliminated, varied, and the fact of their violation conclusively determined. Thus, a secondary rule of recognition will remove the uncertainty of the regime of the primary rules by providing a rule for conclusive identifications of the primary rules of obligations. Secondary rule of change will remedy the static character of the primary rules by empowering an individual or body to introduce new primary rules of conduct for the group or for some classes within it and to eliminate old rules. The remedy for the inefficiency of the social pressure is secondary rules of adjudication, empowering individuals to determine authoritatively whether on a particular occasion a primary rule has been broken. Hart concludes that the introduction of the remedy for each defect might in itself be considered a step from the pre-legal into the legal world, and that certainly all three remedies together are enough to convert the regime of primary rules into what is indisputably a legal system. The union of the primary and secondary rules may be regarded as the essence of the law, for a modern municipal legal system will combine both kinds of rules, and the secondary rules of recognition will unite all the rules of the system, in that all genuine laws will satisfy the criteria of validity specified by the rule of recognition, law, command and orders. The clearest and the most thorough attempt to analyze the concept of law in terms of the apparently simple elements of commands and habits was that made by the Austin in the province of jurisprudence. Determined in many different situations in social life, one person may express a wish that another person should do or abstain from doing something. When this wish is expressed not merely as a piece of interesting information or deliberate self-revelation, but with the intention that a person addressed should conform to the wish expressed. It is customary in the English and many other languages, though not necessary, to use a special linguistic form called the imperative mode. Go home, come home, stop, do not kill him. The social situations in which we thus addressed others in imperative form are extremely diverse. Yet, they include some recurrent main types, the importance of which is marked by certain familiar classifications. Pass the salt, please, is usually a mere request, since normally it is addressed by the speaker to one who is able to render him a service. And there is no suggestion either of any great urgency or any hint of what may follow or failure to comply. Do not kill me would normally be uttered as a plea, where the speaker is at the mercy of the person addressed, or in a predicament of which the latter has the power to release him. Do not move, on the other hand, may be a warning if the speaker knows of some impending danger to the person addressed. A snake in the grass which his keeping still may avert. The varieties of the social situations in which use is characteristically, though not invariably, made of impressive forms of language are not only numerous, but shade into each other, and terms like plea, request or warnings serve only to make a few rough discriminations. The most important of these situations is one to which the word imperative seems specially appropriate. It is that illustrated by the case of the gunman who says to the bank clerk, hand over the money or I will shoot. Its distinctive feature which leads us to speak of the gunman ordering, not merely asking, still less pleading with the clerk to hand over the money. Is that to secure compliance with his expressed wishes? The speaker threatens to do something which a normal man would regard as a harmful or unpleasant, and renders keeping the money a substantially less eligible course of the conduct for the clerk. If the gunman succeeds, we would describe him as having coerced the clerk, and the clerk as in that sense being in the gunman's power. It is obvious that the idea of a command with its very strong connection with authority is much closer to that of law than our gunman's order backed by the threats, though the latter is an instance of what Austin, ignoring the distinctions noticed in the last paragraph, misleadingly calls a command. A command is, however, too close to law for our purpose, for the element of authority involved in the law has always been one of the obstacles in the path of any easy explanation of what law is. We cannot therefore profitably use in the elucidation of the law the notion of the command which also involves it. Indeed, it is a virtue of Austin's analysis, whatever it is, defect that the elements of the government situation are unlike element of the authority, not themselves in obscure or in need of much explanation. And hence, we shall follow Austin in an attempt to build up from it that idea of law. We shall not, however, hope as Austin did for the success, but rather to learn from a failure. If we talk about sovereign and the subject, in criticizing the simple model of law as a coercive orders, we have so far raised no questions concerning the sovereign person or persons whose journal orders constitute, according to these conceptions, the law of any society. Indeed, in discussing the adequacy of the idea of an order backed by threats as an account of the different varieties of law, we provisionally assumed that in any society where there is a law, there actually is a sovereign, characterized affirmatively and negatively by reference to the habit of obedience. A person or body of persons whose orders the great majority of society habitually obey and who does not habitually obey any other person or persons, we must now consider in some details his general theory concerning the foundation of all legal system. For in spite of its extreme simplicity, the doctrine of sovereignty is nothing less than this. The doctrine asserts that in every human society where there is a law, there is ultimately to be found talent beneath the variety of political forms. In a democracy, as much as in an absolute monarchy, this simple relationship between subjects rendering habitual obedience and a sovereign who renders habitual obedience to no one. This vertical structure composed of sovereign and subjects is, according to the theory, as essential a part of the society which possesses law as a backbone is of a man. Where it is present, we may speak of the society together with its sovereign as a single independent state, and we may speak of its law where it is not present. We can apply none of these expressions, for the relations of the sovereign and subjects forms, according to this theory, part of their very meaning. 2 points in the doctrine area are special importance, and we shall emphasize them in journal terms in order to indicate the lines of criticism pursued in detail in the rest of the chapter. The first concern the idea of a habit of obedience, which is all that is required on the part of those to whom the sovereign's law apply. Here we shall inquire whether such a habit is sufficient to account for two salient features of most legal systems: the continuity of the authority to make law possessed by the succession of different legislators, and the persistence of law long after their makers and those who rendered him habitual obedience have perished. Our second point concerns the position occupied by the sovereign above the law. He creates law for the others and so imposes legal duties or limitations upon them, whereas he is said himself to be legally unlimited and illimitable. Here we shall inquire whether this legally illimitable status of the supreme lawgiver is necessary for the existence of law, and whether either the presence or the absence of the legal limits or legislative power can be understood in the simple terms of habit and obedience, into which the theory analyzes these notions. Reactions. Hart began his analysis of Austin's theory of command by referring to the gunman incident. The question of how imperative orders may be separated between ordering and issuing an order, and how they can be utilized as the foundation of law. According to Hart, Austin failed to differentiate between being obligated to do something by a threat and having a responsibility to do it. According to Hart, the position of a person with legal duties differ from the position of someone confronted with the gunman, but Austin runs the two together. Hart suggested rules as a source of a duty in a place of Austin's idea that legal duties consist of the threat of punishment. The concept is straightforward. A rule specifies what you must do. According to Hart, command is not always an order. It cannot be used merely to define what law is. Hart identifies that flaws in the Austin's argument and asserts that we must derive the meaning of the law from it. Rather than limiting ourselves to command as a law, command is a generic term, not an order or an address, as demonstrated by the gunman situation, which is an address backed by a threat, whereas law is neither an order nor an address, since the individuals impacted can be left to figure things out on their own. It is generic, and if we mistake it for an address, we will get mixed up about who it is addressed to and who it is published to. It is not required for the public officers of the people who are governed by the law to be aware of it. If the principal directive is not followed, a public official will generally draw attention to it. Taxation transaction, for example, may be recorded, and if one is unaware of the legal norms governing it, the tax officers may bring this attention to it. He then stipulates his idea of law after explaining the contingent nature of power and the dangers of the depending on it as a source of societal control. The rule of law must have a threat to back it. Superiority over inferiors is required, but Hart contends that this is not why laws are followed. These regulations may be backed up by the fear of penalty, but individuals have a general propensity to follow the rules rather than break them. This is the foundation of the society that has been implanted in people's brain that they willingly support the law and want to punish those who violates, since they have a general habit of compliance. Hart musses about the legal system and its complexity, concluding that in a contemporary legal system, there must be independence, territory and the sovereignty which are not conceivable in a simple system. Hart then moves on to the concept of the sovereignty, which is more difficult in the modern world, since it takes more than a threat to back it up. Hart separates the sovereigns or a group of sovereigns sovereignty into exterior and internal sovereignty. When a majority decides in the favor of sovereign, give him or her authority and works as a subordinate, the sovereign is considered domestically superior. For example, if the adjudicant parliament did not collaborate with the king, there would be no one legal system in England. Hart defines external sovereignty as the ability to make the decision within a region without the influence of outside forces. For example, if the USSR had the authority over the monarch in England, the monarch would no longer be sovereign, since each law passed would have been authorized by the USSR. Sovereignty is a veiled notion. Hart expands on the notion of sovereignty rather than rejecting it. To summarize, a law in a legal system is a journal order backed up by a threat to disobey given by a body that is internally superior and outwardly autonomous. In the concluding remarks, according to Austin, every system of justice necessitates a sovereign who creates the law, who basically is the origin of the law, while remaining unaffected by its range, such as shooter in the bank scenario, who is the exclusive source of instruction and is not subject to the other people's request. Hart believes that this is an erroneous understanding of law, stressing out that laws can have multiple roots and that legislators are routinely held accountable for the legislation they create. Hart shows that, in contrast to Austin's command theory, law have a much broader reach than a courtship commands. Laws are frequently helpful, allowing individuals to carry out the authoritative activities such as drafting wills or contracts with legal force. Hart claims that authority of command is intimately tied to the authority of law, and because the authority of law is difficult to explain, we should reject the idea of command, because it is associated with the same problematic concept. Hart's answer to this difficulty is to replace the word command with the word order. Hart avoids the difficulty by using terms such as orders reinforced by threats and coercive instructions, as well as stipulating the words obedience and obey. So, this was all about today's talk. Thank you for watching this program.